All right, I'm sure that folks are going to continue to trickle in, but I'm going to get started just because I know that some of you are on your lunch hour. And so I wanted to say welcome and thank you for joining us today to hear about the newly proposed amendments to Title IX. So just a little bit about me. I am an attorney. My name is Bettina. I'm an attorney at the law firm of Krokidas and Bluestein, where my practice concentrates in the areas of education and employment. My background is in representing public school entities here in Massachusetts, but I also have a background in civil rights litigation. So for many years, I was a litigation attorney representing individuals with disabilities in civil rights matters throughout the country. So I have a bit of background in both education and in civil rights. So I've been training on Title IX for a few years now, particularly since the 2020 regulations went into effect. I've done quite a few trainings. And so I'm excited to be with you today to kind of talk about some prospective changes that are on the horizon with respect to Title IX. Before we get started, though, that's a little bit about me, but I would love to get a sense of you all and what kind of work you are doing with respect to Title IX. So we have a couple of quick polls that we're going to put up right now, just to get a sense of what folks are doing with Title IX, who's doing Title IX coordination, investigation, decision-making, or what other experience you have. Let's see if that will come up. And we'll give folks a minute to weigh in on that. And then the a second poll I had was around what kind of comfort level folks have with the current Title IX regulations. Those are the ones that went into effect in 2020. I do love the polls. I think they're great. Oh, interesting. Great. All right, so I think we have one more poll, and then we'll sort of jump in. All right. So really kind of a lot of variation in terms of how comfortable folks are with the Title IX regulations that are currently in place. And that's really kind of telling, right? I mean, we've been working with the current regulations for a couple of years now. And that has been my experience as I've done trainings over the last couple of years, is that there's still a lot of confusion out there and a wide range of comfort levels in terms of, you know, how do we operationalize these regulations, particularly in the K-12 context. So let's jump into it. So Title IX of the Education Amendments of 1972. It's a federal civil rights statute which prohibits discrimination on the basis of sex by any education program or activity that receives federal financial assistance. So I know most of the folks here today are public charter schools or public schools generally. You're all recipients of federal financial assistance, and so you're all obligated to comply with Title IX. So what is the obligation, or what is the responsibility of recipients of federal funds? The obligation is to take actions necessary for the prevention and elimination of sex discrimination. The United States Department of Education's Office for Civil Rights enforces Title IX, and what that means, if you haven't, if you've been fortunate enough to avoid any OCR complaints yourselves at your schools or institutions, OCR has broad authority to investigate allegations that a school or school district did not appropriately or adequately respond to a Title IX complaint. When they find a violation or inappropriate response to Title IX by a school or a school district, they can order OCR can order corrective action action for violations of Title IX. And as part of that corrective action, OCR can engage in ongoing monitoring. And so this is true not just of Title IX, but any of the civil rights statutes that OCR enforces. It can engage in ongoing monitoring, and that may be for a period of months and maybe for a period of years, depending on what the nature and extent of the violation. So it's important stuff. It's important to be in compliance with Title IX. It's important to know that OCR has enforcement responsibilities for it. So here in Massachusetts, we also have our own state anti-discrimination statute, which prohibits discrimination on the basis of sex, among other protected classes. So we're not going to talk about the state statute today. We're going to be really just focusing on Title IX and the proposed amendments. But you just need to keep in mind, as I'm sure you already know, that Massachusetts public schools are required to comply with both federal and state anti-discrimination statutes and regulations. But as I said, today we are talking about Title IX. So a little background on Title IX, as many of you know, the United States Department of Education implemented new Title IX regulations. They were adopted in May of 2020, and they went into effect in August of 2020. And many of you have been grappling with that for the last couple of years. In June of this year, on the 50th anniversary of Title IX, USDOE proposed new Title IX regulations. The full text of the regulations, you don't have to scribble this URL down, but I did want to just include it. We'll pop it in the chat. So if you have any interest in reading the 600 pages or so of proposed regulations, you can certainly do that. But we'll go over at a high level some of the highlights, so you don't have to read the regulations. So in June, as I said, in June of this year, USDOE proposed these new regulations or amendments to the regulations. USDOE has said that the proposed amendments are intended to provide greater clarity regarding the scope of sex discrimination, including schools' obligations not to discriminate based on sex stereotypes, sex characteristics, pregnancy or pregnancy-related conditions, sexual orientation, and gender identity. So many of you will recall that the 2020 regulations really were solely focused on sexual harassment. So we'll talk about how the scope of the proposed amendments are far broader to accomplish this goal of having additional protections against sex-based discrimination. The proposed amendments were open to public comment. That comment period ended in mid-September. Based on the amount of time, the last changes were kind of out for comment between the period of time between when the comment period ended and then the amendments were adopted was about, I think, 18 months, a year, 18 months. So we still could be a year or more out before we see some new the new amendments go into effect. So what is on the horizon? So generally, the proposed regulations include what I think is some good news for schools. It has a focus on more flexibility and discretion for schools, which I think will be a welcome change. There's, as I said, a broader application of the regulations beyond sexual harassment. So it includes, the regulations include more clearly defined protections against protections for pregnant individuals and for LGBTQI+ students and employees. And it includes some shifts and streamlining in the procedural due process requirements, particularly with respect to the grievance procedures, that I think will be a welcome change for a lot of K through 12 schools. So the proposed regulations are in many ways, as I said, a significant shift. But let's talk about some of those changes specifically. So the first major change to be aware of is with respect to the scope of the regulations. As I mentioned earlier, the proposed regulations would apply to all sex-based discrimination, not just sexual harassment. So that includes a modified definition of sex-based discrimination and what Title IX would cover. So the new definition, in addition to sexual harassment, the proposed regulations would include a clear prohibition against sex-based discrimination, against sex-based harassment based on sex characteristics, pregnancy or pregnancy-related conditions, and gender identity. Title IX would continue to apply to quid pro quo harassment. So you'll recall that's when a school employee conditions an educational benefit on unwelcome sexual conduct. So that's in the current regulations. That would continue to be a component of the definition. And it would, Title IX, of course, would still continue to apply to sexual assault, domestic violence, dating violence, and stalking as it is under the 2020 regulations. But what it would also cover is harassment that creates this hostile environment. So folks will recall under the current regulations, the hostile environment component of the definition is any unwelcome conduct that a reasonable person would find so severe, pervasive, and objectively offensive that it denies a person equal educational access. And so one of the criticisms of the 2020 regulations is that that really is kind of a high bar, right? That especially with respect, at least in my opinion, with the persistent requirement, seems to suggest that it has to be repeated conduct to meet the definition. Under the proposed regulations, the definition of hostile environment would include unwelcome sex-based conduct that is sufficiently severe or pervasive. So it brings back that severe or pervasive standard from the prior regulations, right? Based on the totality of the circumstances, evaluated subjectively and objectively. So bringing back in that subjective component. Denies or limits a person's ability to participate in or benefit from the school's education program or activity. So that's a significant shift in scope, right? Additionally, under the proposed regulations, the prohibition against sex-based discrimination may apply to off-campus conduct and speech. So under the proposed regulations, schools would be required to take prompt and effective action to address any sex-based hostile environment in its programs or activities, including responding to sex-based harassment that occurs outside of the school's program or activities, but that contributes to a hostile environment at school or at school-based activities. So remember that under the current regulations, schools are not required to address sex-based hostile environment in its program or activity if the hostile environment happened outside of the education program or activity or outside of the United States. So under the current regulations, if you had a school exchange program or a travel abroad program, and there was an allegation of sexual harassment while a group of students was traveling, say in France, Title IX wouldn't apply, because if the conduct happened outside of the US. And in fact, the school would be required to dismiss a complaint of that alleged conduct that took place outside of the United States. So many schools have struggled with this, right? So for example, what about social media posts? So this comes up all the time, right? So a social media post that's posted on the weekend or at night that is harassing or creates a hostile environment at school. A lot of schools struggle with, well, the incident happened in Snapchat, or it happened at the alleged conduct happened at a party on the weekend, but there's spillover into the school environment. And I think that there's been a lot of confusion and a lot of situations because this happens a lot, right? So under the proposed regulations, they make clear that a school is required to respond to a hostile environment that spills over into the school environment. So, and the other reason I think that this is confusing for folks is that we all are used to this concept of bullying behavior, for example, right? Or other discriminatory conduct, violations of Title VI or violations of the ADA or Section 504. The law is clear that if it's speech or conduct that happens outside of school, but it creates a material and substantial disruption at school, or infringes on the rights of another student, then schools can discipline for that. And so there has been a lot of confusion of why there's a carve out, or seems to be a carve out for Title IX. And so the proposed regulations would kind of clarify that schools, would be not only able to respond to incidents that happen outside of school if it impacts the school's environment, but they're required to take prompt and effective action to eliminate that hostile environment at school. In addition, so the Title IX protections under the proposed regulations would be clear that they include former students or employees or visitors. And so that's also another shift in another way in which the scope of the proposed regulations would be broader than the 2020 amendments. And lastly, with respect to scope, I did just want to note, DOE has said that it expects to issue separate guidance, separate regulations or proposed regulations regarding Title IX and sports in the coming months. So any regulations or issues or guidance related to, for example, transgender athletes that's not already in place, it sounds like they're expecting to issue some additional guidance or additional proposed regulations that would then be out for comment at some point. So I haven't seen them yet, but they are have said they're expecting to issue those. So what are some of the expectations for staff and expectations for training? So one thing I will say is, folks are probably familiar with under the current regulations, that there's quite an extensive expectation with respect to staff training. And so that is expected to continue under the proposed regulations. All staff who are not designated as a confidential employee, and we'll talk about what that means in a minute, are required to notify the Title IX coordinator of any conduct that might violate Title IX. So that's an obligation on all staff. It's not just Title IX staff. Under the proposed amendments, there would be expanded training requirements for all staff. So all staff would need to be trained or required to be trained and knowledgeable about their obligations to address sex-based discrimination in the school's programs or activities. All staff would need to be trained and familiar with what types of conduct constitute sex discrimination. So that includes the definition of sex-based harassment, what the reporting responsibilities are, the availability of supportive measures, and what the grievance procedures are. And so right now, most of the Title IX staff, Title IX coordinators, investigators, and decision makers, typically the principal or other administrator, are generally required to be familiar and trained on these topics. But under the proposed amendments, all staff, because all staff have a reporting responsibility. In addition to those topics that all staff would be required to have training on and be knowledgeable on, Title IX staff would have additional training requirements on the Title IX specific roles and responsibilities. So that would be with respect to Title IX complaints, investigations, hearings, decision makings, etc., record keeping requirements, and training responsibilities and posting of Title IX information and materials. School's obligation, what's the school's obligation to respond to sex-based discrimination? So schools would be required to take prompt and effective action to end the sex-based discrimination, remedy its effects, and prevent its recurrence. So this is not new, right? So this should be familiar to everyone. This is a requirement of the expectation that that is expected with respect to all civil rights violations, right? So anytime you have even if it's a Title VI violation or a racial complaint, anytime there's discrimination for any protected category, the expectation in OCR will look to, has the school taken prompt and effective action to end that discrimination and to remedy its effects and to prevent its recurrence. So this isn't new. I just put it up here to remind you all that this is the expectation. In addition to those requirements, under Title IX, the proposed Title IX regulations, schools would have an ongoing obligation to monitor barriers to reporting sex-based discrimination. So in addition to these obligations to end, remedy, and prevent, schools would have this ongoing obligation to be considering, is there a climate and culture that discourages individuals from reporting sex-based discrimination? And I think it would be, if this ends up being a requirement as part of the amended regulations, districts will really want to be thinking about how they would demonstrate this ongoing effort to monitor barriers to reporting sex-based discrimination. So let's just talk for a minute about confidential employees. I mentioned that a bit earlier. So under the proposed regulations, schools may designate confidential employees who would be exempt from reporting potential Title IX violations to the Title IX coordinator. So we just talked about this obligation that all staff would have to report any allegations or information about possible sex-based discrimination. So the only individuals that would be exempt from that requirement would be a confidential employee. So a confidential employee can be a school employee whose communications are privileged under federal or state law associated with their role and duties for the school. So this could be the school adjustment counselor, one of the school therapists, school psychologist, or someone like that, that has an obligation to maintain student confidentiality by virtue of their employment and their role at the school. But in addition to that, a school can designate one or more confidential employees for the purpose of providing services to persons in connection with sex discrimination. So this would be a person that would be designated that would be that students and staff would be informed as a confidential employee who would not be required to share allegations of sex-based discrimination over the wishes of the person reporting that information. And so a student or employee could talk to the confidential employee if they were maybe thinking of filing a Title IX complaint but didn't know if they wanted to, and that they could have that conversation and talk through their concerns with the confidential employee, and the confidential employee would not then be obligated to report that to the Title IX coordinator. So, as I mentioned, there are some proposed changes to the grievance procedure under the proposed amendments to Title IX. And I think some of these will be a welcome change to folks, particularly if you have felt like you've struggled a bit with the details and all of the requirements of the 2020 grievance procedure requirements. So as with the 2020 amendments, there is still or would still be a requirement that schools have a Title IX grievance procedure. And some of the things will be the same, but many of the things would be changed and I think streamlined in essence. So the first main thing is that folks will remember or understand or know, because you're dealing with it, that written notice is required under the current regulations. So current regulations require written notice to the parties of a formal complaint. So under the proposed regulations, sufficient notice is required, including details of the allegations, identities of the parties, sufficient time to respond, etc. But that may be given orally or in writing. Now, it may be best practice to continue to provide written notice. That's always a good option for creating a good paper trail, just for the school's purposes, but it's not required. So that would be one change, and less paperwork for schools, certainly, if they don't want to provide written notice. The other big change is that schools would be permitted to go back to a single investigator model. So this was permitted before the 2020 amendments. And folks will recall that under the present regulations, the Title IX coordinator cannot be, and the investigator cannot be the same person as the decision maker. So this can be a challenge to smaller schools, right? I mean, you only have so many staff, and your Title IX staff have to comply with all of these training requirements. So under the proposed amendments to Title IX, a single investigator model would be permitted, which I think will be a welcome change to folks and give schools some additional flexibility in terms of Title IX staffing, particularly because, and we'll talk about this in a bit, there's still the obligation that Title IX staff be free from conflict or bias. And so especially again, when you have a smaller school, if you have a situation where you have designated Title IX staff, but someone's conflicted out, who do you go to? So this can be a challenge. So the single investigator model would be permitted under the proposed regulations. The other change that I think would be a welcome change is the elimination of this 10 plus 10 day review period element of the grievance process. So that would be a big change as well. Additionally, so no written investigation reports are required. So again, this can be a challenge to folks, particularly when you have a period of time where you're, go in waves and you're getting a number of Title IX complaints. Some of the more complex investigations, producing a written investigation report can take up a lot of staff time. So required under the current regs, but under the proposed regs, no written investigation report would be required. But again, I would just note that that can be best practice in some matters. And I would suggest that particularly in situations that are more complex, that you do continue to do an investigation report just to document that the schools use best efforts to respond in a reasonable and prompt way, the actions that the school took to end the discrimination, remedy its effects, and prevent its recurrence. So again, it would not be required, but maybe best practice. Another element of the proposed regulations that's new would be a requirement that the IEP or 504 team be consulted if either the complainant or respondent is a student with a disability. And this is for a number or a couple of reasons. So one would be in terms of determining appropriate supportive measures for the complainant or respondent, and also for determining the appropriateness of any discipline. So this would be a new requirement, not required under the current regulations. Although again, it's not prohibited. It could be best practice depending on the situation, but would be a requirement under the proposed regulations. Another change would be that there would no longer be a total prohibition on gag orders. So folks may remember that with the 2020 regulations, with respect to Title IX, the school, when it's conducting an investigation, cannot prohibit the parties from discussing the allegations or the evidence. This was, I think, a new kind of area for schools, or a new a procedural piece of investigations, particularly where schools are often familiar with or often do prohibit students from talking about bullying, harassment matters, right? So oftentimes you'll tell the students, like, while the investigation's going on, don't talk about this at school, don't talk about it with your friends, like, zip it until we're done doing the investigation. And that's always been typical practice at a lot of schools. And so this idea under the 2020 regulations, where you could not do that, was new. So with the proposed regulations, we're going back to no total prohibition on so-called gag orders. It would allow schools to take reasonable steps to protect the privacy of the parties and witnesses, but you still have to preserve the right of the parties to obtain and present evidence and witnesses. So it's more of a balance, but no total prohibition. Under the proposed regulations, there is the standard of evidence goes back to being a preponderance of the evidence standard. So all that means is that it's more likely than not that the respondent more likely than not engaged in the conduct that's alleged. Under the the current regulations, the 2020 regulations, schools can choose whether to use a preponderance of the evidence standard or a higher standard, a clear and convincing evidence standard. In my experience, most schools use a preponderance of the evidence standard anyway. I've been recommending that districts, schools and districts stick with that under the current regulations, but schools do have a choice. Under the proposed regulations, it would go back to just being preponderance of the evidence standard for everyone. Another thing that the proposed regulations make clear is that schools and school districts must take into account the age, maturity, and level of independence of the students involved. Now, there was guidance, older guidance from before the 2020 regulations that included language from OCR or DOE, I can't remember right now, but older documentation that mentions just this, that schools must take into consideration the age and maturity of the students involved when considering discipline for violations of civil rights statutes and regulations. And so this is something that I typically have been advising, my clients to take into consideration. And so I'll give you an example. And so this is good practice. I think under the 2020 regulations, there's been some confusion. And so one thing I think that it would be a positive is that the proposed regulations make it clear that schools must take into account the age, maturity, and level of independence of the students involved. And so I will give you an example of a situation that came up with one of the school districts that I was dealing with early on when after the 2020 amendments were enacted. And so it was a group of fourth graders that had all received some wonderful technology for Christmas, some iPhones and iPads. And one of the fourth grade boys promptly used his iPhone or iPad to take a picture of his genitalia, which he then sent to 5 of his boy friends. One of the boys who received the picture then sent it to a bunch of other students in the fourth grade class. And one of the girls' parents reported it to the school. And so there was a lot of hand-wringing. Do we investigate this as a Title IX sexual harassment matter? How do we handle it? And so we kind of landed on addressing it more as a discipline matter, but nobody was disciplined. But we did sort of take the approach that taking into account the age and maturity of the students involved, that there was no intent to harass anybody. It was more just fourth grade foolishness. But in that case, and I will just say as sort of a cautionary tale, you wouldn't always in a situation like that, you do need to file a 51A, right? Because you don't know who really took the picture. I mean, in that case, we felt very fairly certain that it was a boy since he admitted it, but just as a precaution, anytime you have nude pictures of underage students, that's something that needs to get reported to DCF. So that's more of a practice tip. But on the bigger issue of whether that would be something that needs to be investigated as a Title IX, the proposed regulations would make clear that certainly you can take it, and certainly you must, not just can, you must take into account the age, maturity, and the level of independence of the students involved. Certainly that would be a much different situation if the students involved were seniors in high school, right? Okay. And as I mentioned, pregnancy and pregnancy-related conditions, again, this is covered by Title IX, of course, but the proposed regulations provide some additional guidance, some clearer guidance, and express regulatory guidance on protections for individuals who are pregnant or have pregnancy-related conditions, and obligations that schools are required to comply with to accommodate such individuals. So schools are would be required to protect students and employees from discrimination based on pregnancy and pregnancy-related conditions by providing reasonable modifications, reasonable break time for employees for lactation, reasonable lactation space for students and employees. And as I said, you know, the Title IX protection for individuals who are pregnant or have a pregnancy-related condition, not new. The regulations provide some additional clarity on the school's obligations, but OCR did in fact issue some guidance on this under the current regulations earlier this month or late last month. And so I included a URL here. We'll pop it in the chat as well if you want to take a look at that guidance that applies to the regulations that are currently in effect. So those are some big changes that we just talked about. What is expected to stay the same, or as I have here, mostly the same? So the focus of Title IX in terms of the regulations, there's still a heavy focus on equitable treatment for the parties, for both parties, so complainant and respondent. As I mentioned earlier, there's still this obligation that Title IX staff must be free from bias or conflict. And so this is something that you should be thinking about early in the process, right? So you don't want to go through your whole investigation process and have at the end of the process have it come out that your investigator was somehow biased or had a conflict that you hadn't really kind of thought through at the beginning. So requirement under both the current regulations and the proposed regulations. There would remain a presumption that the respondent is not responsible until the final determination made by the decision maker. Burden is on the school to gather sufficient evidence, so not on the parties, on the school. The proposed regulations would include reasonably prompt timelines. That's true under the current regulations too, right? So no hard and fast deadlines. There's no, you know, investigation has to be completed in 60 days. It has to be reasonably prompt. And so what reasonably prompt means is going to be different depending on what the allegations are. If you have a very complex Title IX matter involving numerous complainants or numerous respondents or both, that's going to take you longer than something that's much less complex. So it has to be, you know, reasonably prompt. There is, of course, a prohibition against retaliation. That's true for any civil rights allegation, true under the current Title IX regulations and under the proposed regulations. And the proposed regulations also still have a provision for supportive measures. So those are available with or without a formal complaint. And the grievance procedures should describe a range of supportive measures. So supportive measures should be individualized, reasonable, and remember they have to be non-punitary and non-disciplinary. Informal resolution, so that is optional under the 2020 regulations. It would remain optional, so schools can decide whether or not to offer an informal resolution process. You know, you may get different guidance on that. Some attorneys don't advise offering an informal resolution process, and the reason for that is that sometimes there is a concern that students will feel pressured into participating in an informal resolution process instead of having the opportunity to engage in the formal Title IX process. You also would need to spell out what the informal resolution process is. So just because it's informal, you still need to have a process. And so it's yet another process in addition to the formal Title IX process. And so, so it's optional under both the current and proposed regulations, and schools can decide whether to offer it. Under the current regulations, the 2020 regulations, if informal resolution process is offered by the school, it's only available if a formal complaint is filed. Under the proposed regulations, if the school offers an informal resolution process, it's available. It needs to be available whether or not a formal complaint is filed. But let's just remember that the 2020 regulations are still in effect. And as I mentioned earlier, they may remain so for a year or more, maybe a year and a half. It's hard to know. So schools should be considering ways that their Title IX processes may need to change when new regulations are implemented. So I think a lot of these aspects, or that at least the grievance procedure components that we've talked about today, I think are probably likely to be implemented. You never know for sure what the final regulations will look like, but there's some things that you should be thinking about, and that's why I wanted to kind of give a highlight or an overview of some of the proposed changes. But you still are required to comply with the 2020 regulations. And that means the current definition of sexual harassment, again, it includes quid pro quo, sexual assault, dating violence, etc. But the hostile environment component is still this unwelcome sex-based conduct that is so severe, pervasive, and objectively offensive that effectively denies a person equal access to the school's education program or activities. So that's the current definition under the 2020 regulations. Also keeping in mind the obligations with respect to evidence, written reports, and applicable timelines. And so while I had just mentioned that there's no strict timeline in terms of how long your whole investigation decision-making process must take, there is this requirement of the 10 and 10-day rules, which are that you must provide all evidence to parties with at least 10 days to inspect, review, and respond. And parties have to be provided with an investigative report with at least 10 days to review. So we're stuck with that for now. I know that schools really struggle with some of these timelines and some of the written report requirements, but we're still obligated to comply with those for now. Other things to keep in mind, the training obligations for Title IX personnel and decision makers. So your investigators should, be trained and knowledgeable on how to conduct an investigation. Your Title IX coordinators should be trained on all of the things that the 2020 regulations require training in. Title IX personnel should be familiar with the rape shield protections, appeals procedures, all of that stuff. Written notice is still required. So while that would go away under the proposed regulations, written notice of a formal complaint to both parties is still required. Decision maker cannot be the Title IX coordinator or investigator. Notice and posting obligations. So remember that any Title IX training materials need to be posted on the website. All Title IX records, so complaints, investigations, finding letters, need to be maintained for a minimum of 7 years. And that is our highlighted overview of the proposed amendments. But I am happy to answer questions, not just on the proposed changes, but also on current Title IX. So I know folks oftentimes have questions on that as well. So I'm happy to answer questions that folks have.
Bettina would like to start you off with a really hard one here.
Okay.
Will your slides be made available following the presentation?
Absolutely not. No, absolutely. We absolutely will circulate that. I'm happy to. I think if we have a list of all the registrants, so I'm happy to send that out. So absolutely, yeah.
Great. Then for the rest of the questions here, I'm just going to be reading a few off, and I'm going to try to make them as clear as I can based on the very short questions here. When we talk about sex-based conduct, is the perception there as perceived by the individual or by a reasonable person?
So that's a good question. So under the current regulations, it's conduct that's so severe, pervasive, and objectively offensive. So it's an objective standard, right? And so that's can be a high bar to meet, right? So under the proposed amendments, I'm just trying to pull up the language because it's changed. Sorry, bear with me. But under the proposed regulations, sorry for jumping around. Under the proposed regulations, the definition would be severe or pervasive. So it's an either or based on the totality of the circumstances. So that's another element for consideration. And it has to be evaluated either objectively and subjectively and objectively. So all of that is to say, I think under the proposed regulations, there's a lot broader room for a finding of sex-based discrimination that is perceived subjectively. Again, it has to be based on the totality of the circumstances. It has to be severe or pervasive, but I think that it's not as rigorous or a high standard as under the current regulations. I don't know if that, hopefully that answers the question.
And if anybody feels like their questions are not sufficiently answered here, feel free to ask another question in here. We're going to answer as many as we can within the conversation here today. And then Bettina, you'll be following up, right?
Yeah, so what I was hoping to do, and I hope that folks will find this helpful, is in addition to circulating the slides, we're going to collect all the comments, and then I will send out kind of an FAQ that tries to answer all the questions that were answered here, and maybe in a little more detail if folks don't feel that they're answered here.
A little bit of a lightning round here when it comes to questions about confidential employees. Can the Title IX coordinator be the same as the confidential employee?
No, because the whole idea of a confidential employee is that if I am a student and I am thinking about making a Title IX complaint, or I'm not sure that something was Title IX and I want to just talk to someone about it, under the regulations, any school employee has an obligation to report any Title IX potential violations. So the idea of a confidential employee is like a safe space for someone to have a conversation without worrying that that information is going to be shared with the Title IX coordinator. And so if you have the Title IX coordinator playing both roles, it would be a conflict, I guess.
Should the expectation be that the confidential employee receive a deeper training in Title IX than a general staff member?
I don't think so. I could look back at the regulations about that. I think that with the expectation is that everybody understands the obligation to report, the obligation to respond, what is sex-based discrimination under the regulations. So, arguably they wouldn't need additional training beyond, the only people that would get it or be required to have additional training would be the Title IX specific staff with respect to Title IX specific things like conducting an investigation, conducting a discipline hearing, a findings hearing, a decision-making hearing, etc. So I don't think there is a requirement for special or additional training. I think the school could just designate someone for that role, but it would only be with respect to Title IX. So if there are other reporting obligations, so for example, it wouldn't mean that you wouldn't have your mandatory reporting obligations under 51A or something like that. So I think
for confidential employees speaking with students under the age of 18, do they seek the student's consent, the parent's consent, or both when it comes to reporting?
So again, my understanding of the role of the confidential employee is that it's just someone that the student can bring a potential allegation of sexual harassment to without feeling like they have to report it to Title IX and it's going to trigger a Title IX investigation. So I don't think that they need any consent from any, the idea is that the school says this is a confidential employee, students and staff would be informed, like this is a person and this is their role. You can talk to them about sexual harassment allegations, and they're not necessarily going to share it with the Title IX coordinator who would then conduct an investigation unless you want that. But I don't think there's any other, like they wouldn't have a notification to the parents or anything. Again, unless there's, I would have to do a deeper dive into the confidentiality requirements. Certainly if there's an allegation of something that would be abuse or neglect, that would be reportable under 51A, that there may be a conflict there. But typically it would just be a person that staff or students could go to kind of brainstorm, like I might want to file a Title IX complaint, I might not, can you talk to me a little bit about it?
Okay. When it comes to somebody who's being appointed to do informal resolution, are there formal regulations for someone like that or just guidelines?
So my recollection under the current, and I can look at this again, but because again, a lot of my districts our schools do not offer the informal resolution process. But I think the requirement is that you have a process and a person. I don't think that there's additional training that whoever's involved in. I mean, maybe the Title IX coordinator runs the informal resolution process. That could happen, and that might be typical for schools that offer it. But the process itself is not, under the 2020 regulations, is not set forth like you have to do it this way. You can have whatever informal resolution process you want that's fair and impartial and isn't coercive or things like that. And the Title IX coordinator could be in charge of that, but it could be somebody else.
I had a follow-up question to the question about students, parents, or both. If a student doesn't want to talk, but the parent does want to talk, is there any way of kind of mediating that dispute?
Yeah, so so this comes up a lot, right? Or not a lot. I've seen this a bunch. So student reports to parent, this person is, saying things that make me uncomfortable, but I don't want to make a big deal of it. Like, I don't want to report it to the school. I don't want to make a big deal. I don't want to do anything about it. The parent's upset, the parent goes to the Title IX coordinator. Under the present regulations, there is this requirement, right, that that the school and the Title IX coordinator have to defer to the complainant's wishes. So the complainant, I would say, is the student, unless there's compelling circumstances that, it would be unreasonable for the Title IX coordinator not to pursue the allegations over the wishes of the complainant, right? So, I think under the current regulations, if a parent wants to file a formal Title IX complaint, but the student would otherwise be the complainant or victim does not, I think that the Title IX coordinator needs to not pursue it if the student doesn't want to, unless it would be unreasonable to do so. So an example of that might be an allegation of sexual assault or something severe, where the student says, I was assaulted, but I don't want to make a big deal of it. I don't want people at school to know. I want to just forget about it. I think if the parents have that information and share that with the Title IX coordinator, I think the Title IX coordinator would still need to pursue that, and obviously being mindful and sensitive to supportive measures, having a conversation with a student about why this Title IX coordinator is obligated to pursue it. A lot of things that are going to be required to try to navigate a situation like that. But all of that is to say, if it's, so-and-so sent me inappropriate texts, but I don't want to make a big deal of it and I want to just forget about it. Like, let's just move on. I think the Title IX coordinator has to respect the wishes of the student in that circumstance.
Thank you. When it comes to reporting, are schools required or are schools encouraged to report Title IX cases to DCF?
So that's going to depend on the circumstances. So just keep those separate, right? So Title IX is a civil rights statute, and 51A and related requirements with respect to mandated reporters are different. So you would want to be familiar with your obligations as a mandated reporter. So certainly any violations that would trigger that reporting would need to be complied with, but not every, and folks know this, right? So not every Title IX violation is going to be something that would constitute an allegation of abuse or neglect of a minor. So it's gonna depend. I did give that example of the picture of the student the fourth grader sending a picture of his genitalia to his pals. That, again, anytime you have like nudity pictures, things like that, I would err on the side of reporting it. Again, with a fourth grader, DC, in that situation, this did happen. DCF, of course, screened it out when they got the facts, but I would err on the side anytime there's nudity or anything involving a minor, I would file for sure. But not necessarily, I mean, all of that is to say any Title IX violation isn't not necessarily going to be a something that triggers a mandated reporting situation.
Okay. Maybe one more question here while we're doing the slide, but obviously you'll be following up on the Q&A here.
Yeah.
Are there no changes to the prohibition on issuing any sort of discipline until the completion of the entire Title IX process?
Yes. You know, again, I think this is a tricky one. I think that I have seen schools and districts, you know, in a situation where there's an obvious violation of student code of conduct to discipline prior to the Title IX investigation being completed. And the rationale for that is that, you know, they're separate and distinct. But generally, yes, you would want, if you're going to be disciplining for a violation of Title IX or related school student code of conduct violation, you would want to wait till there was a finding. But again, if there's an emergency situation, my advice is always to schools to, you know, take whatever action is necessary to keep the school and students safe. And so that's going to be very fact specific, of course. But generally, yes, there is still a requirement that the process has to play out before you discipline for it.
Are you up for any more questions, or do you want to wrap up?
Yeah, no, sure.
Okay.
I mean, I know that some folks are on their lunch break, so I will not have hurt feelings if you jump off, but I'm happy to stay on for a few more minutes and answer questions.
Okay. Would you please review the steps that need to be taken under the current regulations when a situation is disclosed at school?
When a situation, I'm assuming it's a Title IX situation.
For example, a male student accused of inappropriately touching a female student.
So under the current regulations, I would have a conversation with the alleged victim complainant. If the complainant wants to file a formal Title IX complaint, the Title IX coordinator would give the Title IX complaint form or help them fill it out. And that would initiate the Title IX investigation process and all of the steps that go along, you know, which would be set out in your grievance process. If the student does not want to file a formal Title IX complaint, then the Title IX coordinator would need to make a determination. Would it be unreasonable for me, the Title IX coordinator, not to pursue this? So it's either the complainant can file a formal Title IX complaint, or the Title IX coordinator can initiate the formal complaint. But there is this requirement that the school Title IX coordinator of the school defer to the complainant's wishes. And so that's going to be a balance, right? It's going to depend on the nature of the circumstances and what the complainant's wishes are.
All right, we're almost to 1 o'clock here, so it seems like a good time to say thanks to Bettina and wrap up.
Thanks, everyone. And again, I will take the comments or questions that we have not been able to get to, as well as the ones that we've covered, and I will try to put those into a document that I will circulate. But the first thing that you'll probably receive will be copies of the slides. So thanks, everyone, for joining me today.
Thank you.